Georgia lawyers Bob and Irreverent D talk law. Listen up for stories about how things really happen in our legal system. Who are these guys? Dwayne Singleton, Irreverent D, is a criminal defense attorney in the state of Georgia. Benjamin O. Benson, aka Bob, is a personal injury attorney in Atlanta. Today, the boys are dockside in Miami when Bob gets tickled. And Irreverent D talks about legal fees.
And the answer,
$1 billion.
$1 million.
And then Bob. We'll come back to that. Dwayne impersonates a bee. While Bob... Oh, forget it. Now, sit back and take a listen as Bob and Irreverent D talk law.
Got a Franklin Covey planner there.
Do you want to? Yeah. Do you like this? I've really, Dwayne, I've really gone back to like pen and paper.
Yeah.
I
had a Franklin
nature.
Covey for years that
Really?
I used.
For me, it's the physics of it,
Yeah.
right? There's an importance to having it here where I can touch it and I can feel it.
I still like written books. I still buy the books.
No, that's just a little too old-fashioned for me.
Well, I
you
like
are
it
old.
because I like to have my tabs.
Oh,
I know
like
where
your
it's
dog ears?
physically at. Like I know, I can't think of the section, but I know what I'm generally looking for, and I know it's here.
You generally, yeah, that's
Like
true.
I know,
But
I have
to be
a feel
fair,
for it.
Right. To be fair, we grew up like that, though.
Right.
I've always thought that the generation. So speaking of 8-year-olds, right? That generation, that they would just somehow be more naturally inclined to, spinning through a PDF document than we would, because we grew up paging through something like this, right?
Well, did you ever do Bible drills in Vacation Bible School?
Yeah. Yes. Did that go as fast as you can.
Yeah.
But you know what? I don't think that's going to happen with the new generation, because they still grow up on the cardboard books like Goodnight Moon. They still have physical books as they're growing up. And until that changes to all digital from 3 months old all the way through, there will still be people who need to go through and see, okay, this is what we're dealing with, and this is what we're dealing with. You ready to go into the news?
In a situation like today where your phone dies.
Where your phone dies.
And you don't know where you're going to go, and you can't get it charged.
So you had to drive around to try to find a place where you could find a charger.
So I could charge my brain. So I could figure out where the marina was at.
So in the last episode we talked...
Because I had no GPS.
Right.
Right? I had no address, and I had no way to call anybody. And
like, how do you even know where you're supposed to go?
And my phone charger the port was broken, so I had to find one that you could lay it on top of, and they didn't have one at the airport for sale. I bought one for the watch, but it wouldn't work on the phone.
So you ended up having to go get a rental car, and then you had to roam around.
I literally drove like a grid pattern out
from the airport
until
to try to find a place
until I found an Office Depot.
An Office Depot to find the charger for your phone, so you could charge your phone.
Yes.
So you could put it in the GPS.
Yes.
So you could get here to meet us.
Yes.
Oh God, I love you.
It's like a 2-hour ordeal.
The things I do for you.
Just insane. And then y'all were waiting here with a broken boat.
I know, right? turns out didn't make much difference. Oh no! All right, so let's talk about the news. You want to talk about the news?
Let's do it.
All right.
And now, the news.
Here's what happened. In Gwinnett County, these two lawyers, one from Morgan & Morgan and one from the Hawk Law Firm.
Okay.
All right. They got a verdict of $1.5 million between their two plaintiffs, a husband and a wife. And that $1.5 million was quite a bit bigger than the amount of their medical damages.
Okay.
And the whole story is about how did they get there? And here are the details. Well, this all started in 2017, where this couple was driving along, minding their own business, as they're wont to do, and some reckless driver, negligent driver, knocked into somebody, knocked that person into oncoming traffic and hit our two clients. So it was a horrific wreck.
Right.
Our client, not our clients, but the
client.
plaintiffs, they went to the emergency room. They had medical treatment with a physical therapist. They had medical treatment with an orthopedist. The one spouse had, $165,000 in medical bills.
Wow.
That's a lot. A lot of it was the emergency room and the physical therapy, but there's also, quite a bit from the orthopedic doctor. We don't know exactly what kind of medical treatment they had with the orthopedic. We just kind of know generally how it broke down. The other spouse had about $80,000 in medical bills. At trial,
What was the total verdict? 1.5?
yeah. So at trial,
Okay.
the first spouse that had $165,000 in medical bills got a verdict of $1.2 million.
Okay.
And the
So
other,
about 10 times medicals.
yeah, I mean, really like 9 times,
Right.
8 or 9 times what the medical bills are, which
Okay.
is it's a big verdict.
Yeah.
The other,
But it's not 100 times medicals.
no, but I mean, you
Right.
very rarely see that.
Right.
Okay. The other spouse who had $80,000 in medical bills, they had a verdict of $361,000 or $360,000.
Okay.
So that's roughly 4.5 times their medical bills. So we use that kind of benchmark to say, because juries kind of tend to think that way, right? Like the question is, how bad were you hurt? The answer is, well, how much were your medical bills?
Which I hate that.
I mean,
Because if I have a giant scar across my chest or if I lost a pinky,
that's true.
Right.
You broke your leg.
my medical bill may only be, $15,000, but I don't have a pinky.
Yeah, that's true.
Right.
But I mean, but those are kind of the exceptions.
Okay.
Generally speaking, if you were hurt really bad, your medical records and your medical bills ought to reflect like basically how bad you were hurt.
I know, but we're not cars.
No, that's true. That's
Okay,
true.
all right.
But but still, we're still dealing with, you and I have seen enough injuries
Yeah.
that we kind of know, okay, well, it can be different,
Sure.
right? But jurors who maybe this is the only civil case they ever have to sit on a jury for,
Need a formula.
right? They need something to go by.
Right.
Right. So this particular case, though, I mean, if you have permanent injuries, the real question is, well, how much is a jury going to give you for your pain and suffering? Because you figure if you've got $165,000 in medical bills, well, you ought to at least get that,
Right.
because that's what your medical bills are. Then the question is, well, how much beyond that should your pain and suffering be? And the question and the
$1
answer,
billion.
$1 million, right? The answer is nobody really knows.
Right.
Essentially, and because nobody knows, this is generally what happens, and this is what happened in this case. The plaintiffs had told the defendant, listen, if you'll settle for $250,000 each, so $500,000 total, we'll cut you loose. Everything will be done. The defendants ignored it. They said, well, I don't know what they said.
Right.
All we know is that from the article is that they didn't respond to it, according to the plaintiffs. Then, fast forward, probably by the amount of years, because these injuries happened in 2017. They tried the case in 2022. So 5 years later, a week before trial, the defendants make an offer to the plaintiffs of
$500,000?
Yeah, $250,000 each. They
Gotcha.
say, hey, got an idea.
Right.
How about we offer $250,000 each? And, I don't know exactly what the plaintiff's attorney said, but I imagine it must have been something like, screw you.
Right.
We made that offer years ago, right? Like you had your chance to.
So was that the policy limits? We don't know.
We don't know that
Okay.
that's policy limits, but if you're having to read between the lines, and we do,
Right.
if you're having to make reasonable inferences about what's going on here, you kind of suspect, okay, that's
So they made a policy limit demand. They denied to pay. They didn't pay it, and
That's
then
right.
they came in and got a bigger verdict.
and they got a bigger verdict.
Right.
So the question is, well, one, how did they get a bigger verdict than, the $500,000 that was being offered to the two spouses? And two, well, what's going to happen now? Like they've got this $1.5 million verdict. Are they going to be able to collect on it?
Right.
So the answer to the second question is we don't know, because we don't know we don't know what the answers are here. The answer to the first question is, well, they took a gamble. The plaintiff's attorneys gambled that when they went in front of a Gwinnett County jury, that they would be able to get the Gwinnett County juror members to really identify with their clients and see, man, this has really impacted our lives a lot.
But the defense attorney is taking a gamble.
That's right.
But they're gambling with somebody else's money.
Right, we talked about this in the episode with Adam, right?
Right.
That they're gambling with somebody else's money. We don't know that. You and I don't know that, but we reasonably suspect that the insurance company...
But as the plaintiff's attorney, you're gambling with your money.
That's what...
I mean, if you get a goose egg and you've got your 40 grand in, 50 grand in, that's just 50 grand you just threw off in the ocean.
Yeah, I mean, I don't like to think about it that way.
Well, no, you go crazy if you...
Yeah.
if you thought about it.
No, I mean, because for me, I mean, okay. If I have 50 cases, I'm not likely to lose, because I've got 50 cases and I've stratified my risk.
Right.
Right. My client ain't got but one case.
Right. Right.
And for them, it's gambling.
Right.
For me, it's not gambling as much, because, in the scheme of things, I'm going to make money because I have enough cases to spread my risk out.
Right.
Right. And so it's, I don't want to, I appreciate you sympathizing with me for the money I might lose on a particular case. But my business model is I represent a bunch of people.
Right.
And that way I'm able to keep the lights on, because, if there's a case that we get a goose egg on, 49 other clients.
You're not going bankrupt.
I'm not going bankrupt, right? I mean, we don't make a killing, but we keep the lights on. We support our employees' families and ourselves, and we're able to do that. But really, the key thing when we're talking about the gamble is my client's gambling,
Right.
because they ain't got but the one case. So in either case, whether you're on the plaintiff side of that or you're on the defense side of that, it's a gamble of sorts.
So what's going on with? Are they going to pay that judgment, or what's going to happen?
We have no idea.
No idea.
We have no idea. What we know is that that they did make an offer. So the plaintiff's attorneys made a reasonable offer to settle the case early on, and that was their way of not gambling with their client's case.
Right.
And because the defendants ignored it
For 5 years.
for a bunch of time, we assume it was a long
Hoping
time.
that you'd go away.
Or just saying, look, you're in the article, the plaintiff's attorneys talk about how the defense was really centered on the defendants accusing the plaintiffs of being lying liars who lie, essentially, and saying you're making a big deal out of nothing. You're blah 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 blah. And the plaintiff's attorney's impression of the way that the jury responded to that was that was not the right way to treat these two people who got seriously injured in this accident. So the main thing is that the plaintiff's attorney did the right thing by making an offer that didn't gamble. The defendants really kind of, to me, gambled wrongly.
Right.
Now, it's not very often that you see a jury award 10 times, 8, 9 times what the medical bills are, or even 4.5 times.
Well, I'm sure they didn't think their exposure was that bad, or
No.
they would have made another offer.
You would have thought.
Right.
You would have thought. But, the reality is that the insurance companies, they can tolerate that kind of hit every once in a while.
Oh, they got more money than God.
Yeah.
Yeah,
I mean, you say that.
Yeah,
You
they
say
got
that.
plenty
But,
of money.
all right. So,
They
so
got plenty of money.
I was a State Farm insured,
Right.
and I would get every year a little statement, because State Farm is a mutual company, so every policyholder is essentially a co-owner in the company. And so I would get like a statement as to, how much they were making. And, so I would analyze that statement. I can't remember exactly what the numbers are, but I'll give you kind of an example, a sense. We collected $55 billion in premiums.
Right.
And then we paid $54 billion in claims. And then it cost us $3 billion to administrate those claims. We had a net loss, actually. Many insurance companies operate on a net loss of claims after having paid 98% of their premiums in claims and then had to pay.
What are they paying their executives? What are they paying their CEOs?
That's not the point. The point is the way they make their money is not on holding on to premiums and not paying claims. It's on holding on to premiums and investing the money
right
on what we call the float, right? So they hold. So, having $55 billion in your hands
float
that you can invest in
and
something,
have cash flow, and
that's right.
have that
will
return a profit.
That's right. That will allow you to make $2 billion.
Right.
And so you've got this big, huge amount of money, and we're paying everything except for just a little bit about that money. But while we have it, we're making, this much.
Only a couple.
But that's still
just a
couple
billion dollars.
Just a couple billion. Right. They're just making a couple billion, and
sad.
Which is fine
You've
until.
convinced me.
Yeah.
You've convinced me.
The poor people.
I'm going to start a fund, a GoFundMe page.
So that works great until you have the markets crash.
Right.
And then you got a problem.
Which a whole nother topic.
Thankfully, that's not happening quite yet. But in
we came close.
In 2016, it was really bad.
Yeah.
2016.
2008, it was hard.
2008, it was hard. 2016 was particularly hard because there was like 2-3 major hurricanes, all in the span of 4 months.
And all of a sudden, you'll see cases just stop settling.
Mm-hmm. Yep.
Because
we saw that.
They have got to divert their money other places.
That's right.
Yep.
Because they can't afford to pay.
Yep.
They're operating serious loss.
Yep.
Right. And it doesn't take that much for them to be in serious trouble.
Well, you see that change too in financials with administration change, like when administration changed with Social Security, where all of a sudden Social Security claims started getting paid out, and then changed and they stopped getting paid out, and then they started getting paid.
You're talking about people who are applying for disability?
Yeah.
That does happen, depending on what regime is in at a particular time. When there's a conservative person in the administration, it tightens up, right? And when there's a more liberal president in the administration,
same case, same facts.
Yep, I've seen it.
Yeah.
Yeah.
The market does good, then they're more likely to pay out claims.
Yeah. We always pray for there to be a good financial market.
Right.
Because bad financial markets are bad for my clients. They tighten up, they start making, crappy offers, and that's a problem.
So when you're taking on a PI case and you're doing an evaluation, you're trying to figure out what it's worth. Mm-hmm. What are the factors you look into?
Okay. So first of all, I don't take a PI case.
Okay. A client.
I only have clients.
Sorry.
We don't have cases.
We've had this discussion before.
We don't have cases, we have clients. Right? So the main thing is this. Every case.
They're people.
They're people.
His name is Jim.
That's right. His name is Jim. There are 3 parts to every case.
Okay.
Liability, damages, and coverage. Think of it like a triangle. Each side of that triangle has to be there, has to be present, and has to have some kind of volume to it for there to be a case. So I'll give you a couple of examples to illustrate my point.
So I see the thing online that says, put in here and find out what your case is worth.
Oh God, please don't use that.
That's not how it works.
No, for the love of God, do not use that.
Okay.
So, I want to say it's complicated, because not much in life is really complicated. There are some things that are tedious, that maybe have some more moving parts, but not much is really complicated. This is simple. You have liability, you have damages, and you have coverage, right? Liability means that somebody did something wrong. So if somebody did something wrong and hurt you, you are entitled to be compensated for your damages.
To make me back whole.
To be compensated for your damages.
All right.
Like nothing can really make you back whole.
Okay.
Right? If you wanted to be made back whole, the law would require somebody to like apologize to you,
Right.
to make you feel better, like maybe give you a back rub. But we don't like our society has decided we don't really care about apologies. What we care about is cash, right? and cash is just fine. It's a nice way to quantify exactly how you've been harmed,
Right.
what your harms and losses are. So you've got liability, means how at fault is the other person. You've got damages, which means how bad were you hurt? And then you've got coverage, which means, well, who can pay for it? Or how can it be paid for? Or how much can be paid for? Every single client that I have, we have to look at those three sides of the triangle to determine, okay, what kind of case do you have? And one, can we help you with it? And two, do you and I look at your case pretty much in the same way?
Right.
All right, so the first part of that is liability, right? And that means, well, okay, there are some circumstances where liability is clear. I'm driving down the road. You rear end me because you're trying to
Charge myself.
You're trying to charge your phone, or you're trying to find a place where you can charge your phone, and you're looking around everywhere, and you're supposed to be paying attention to the road.
Right.
You rear end me. It's pretty clear that you are liable because you shouldn't ought to hit me in the back of the car.
Right.
There are other circumstances where it's not so clear. For example, there's a merging lane, right? And this lane is going straight, and this lane is supposed to be coming in on it, and both of us are trying to go in the same lane at the same time. In that circumstance, well, maybe it's not so clear about
Right.
who's liable. Or there may be a classic swearing contest. I've got this situation right now where my client swears up and down she was driving through the intersection with the green light. And the other lady, who went through a red light, swears up and down that she had the green light. And so the question in that case is, well, who is at fault and how do you prove it?
Right.
And so you can have clear liability, which make this part of that triangle big, or there could be very unclear liability or contested liability that make that part of the triangle small.
And all that affects your determination of value.
That's right, because if you have a small leg of your triangle, it makes your triangle smaller.
Right.
Okay, so then the second part of that is damages. Damages is, well, how bad were you hurt? And we talked about earlier, a lot of times, first of all, what matters when we're talking about how bad are you hurt is not really what an insurance company thinks or what an attorney thinks. It's what a jury or a judge thinks.
Right.
We don't like to have to make a jury or a judge make that determination because it's expensive to do that. It costs a lot of time and energy and money and mental stress and all that kind of stuff to go all the way through from where we are to we have a jury trial and the jury decides and you gamble and you say, jury, the should be worth $15,000. And the jury says, no, it's worth $8 or whatever. Like you don't, like we don't have to like to go through all of that. And so we have generally benchmarks or things that give us some kind of indication of what juries or judges are likely to do in certain circumstances. And we kind of know, well, okay, if your medical bills are low and you fully recovered from your injuries, well, generally speaking, your pain and suffering is going to be low. All right, so you have $2,000 or $3,000 in medical bills, and you fully recovered from your injuries, didn't have anything more than you went to the emergency room. Well, then we think, well, we go in front of a judge, we go in front of a jury, the jury thinks, well, they were hurt, but they weren't that hurt.
Right.
And that's probably right, unless it's one of those situations that you were talking about earlier, where you have like, I broke my leg.
Right.
And all, it only cost $2,000 for me to go to the emergency room and be in a cast for 8 weeks. Then you would get a much higher kind of pain and suffering verdict in those circumstances, but those are pretty limited circumstances. You would know them. But generally speaking, if you have whiplash and you have a couple $1,000s in medical bills, well, a jury thinks, well, they were hurt, but they weren't that hurt.
Right.
It's a little something. On the other hand, if you have a lot of medical bills, like so in this circumstance, this person had $165,000 in medical bills, a jury would think, what?
It's worth a lot because there's a lot of medical bills. They're hurt
Right.
pretty bad.
This guy got hurt really bad.
Right.
Why in the world would he have $165,000 in medical bills if he wasn't hurt so bad? And so you would see a bigger, and you see that in this particular case, right? Somebody who had $165,000 in medical bills, and probably, now this part I'm guessing, probably a doctor that says, well, and they have permanent medical condition.
Right.
Then a jury is thinking, golly, that person really hurt. Whereas in the flip side, this other person who had $78,000 in medical bills, a jury thinks, well, they were hurt, but not
quite as bad.
Yeah, not quite as bad, right? And so they get 4.5 times what their medical bills are for a verdict. Again, like I said earlier, it's kind of unusual to see that big of a modifier for pain and suffering based on those medical bills. But you know, if you have a client who is likable, and you have a doctor who's saying, yeah, they're permanently messed up, and I'm in front of the jury arguing, well, this person, they're described as retirees, so I'm assuming they're in their 60s or 70s, right? This person is going to have to spend the next 2 years, or so next 20 years of their life expectancy in constant pain. What is that worth to you?
Right.
And you get a jury who's sympathetic to that, then they're going to give them a big pain and suffering verdict. So that's the damages part. It can be as little as little. It can be as big.
Right.
Depending on any number of factors. But basically it comes down to how bad were you hurt.
So what you're saying is there's no magic calculator.
There's no magic calculator.
Got it.
Right.
Got it.
Now, what I will say is, when you're talking about medical bills and how bad were you hurt, there's kind of a BS detector. BS detector? Well, there's like a smell test, right? So if this person had $165,000 in medical bills and they go in front of a Gwinnett County jury, and the defense attorney shows the damage to the car, and there's like a dented bumper,
right? The
jury maybe think, nah, that doesn't pass the smell test.
Right.
In this particular case, there's horrific property damage, and so there wasn't that factor.
Right.
All right. So then the next thing, so we talked about liability, we talked about damages. Those are just 2 parts of the triangle. The third part is, well, how much coverage is there? And that's the part where a lot of people get tripped up. They think, well, I'll talk to them and I'll say, hey, listen, Jim, you have a really good case. You got a lot of damages. You're really hurt bad. And this other person that hit you, they were really wrong, right? They were drunk. They were texting. They were Snapchatting at the same time, doing a speed test on whatever.
Nice.
They're super, super liable, like really bad conduct. But they only have $25,000 in insurance coverage. My client says, what are you saying, Ben? Are you saying my case isn't worth more than $25,000? I'm like, no, your case is worth hundreds of thousands of dollars because your damages are so high. I'm telling you that we're looking for a pocket of coverage to pay for it. And that's where it really gets nasty.
Right.
Because if you're the kind of person, Dwayne, who only has $25,000 in insurance coverage, and say you're driving a 1992 Honda Civic, then what I'm thinking to myself when I look at that, I'm making some reasonable inferences. I say to my client, hey, Jim, love you, but this guy who hit you, he doesn't have anything.
Right.
And what we don't want, it's fine to have a claim that an insurance company can pay for, but what we don't want is to have a claim against an individual who can't pay.
Right.
Because an individual who can't pay will do one of 3 things. If they have a job, they'll quit it, so that you
Can't
can't
recover.
right, so you can't garnish their wages.
Right.
If they have a bank account, they'll gut it, so that you can't get any money, you can't garnish their bank account, or if they have any of those two things and they don't do either of those two things, they'll file bankruptcy.
Right.
And just say, well, sorry. And unless the judge in the bankruptcy court says, no, you can't do that,
Then they're judgment proof.
then they're judgment proof.
Yep.
All right. So we're always looking at liability, damages, and coverage, who can pay. And we always want to have an insurance company their entire job is to pay claims.
And this is where we disagree. I think that we should increase the limits to 100,000, and you're saying it's personal responsibility.
Yeah, that's true.
I've found
That's
that
true.
people aren't necessarily personally responsible very often.
I don't know. Dwayne, I'm a pretty conservative guy. And so what I often tell my clients is, look, if you have something to protect, if you have a family to protect, if you have a job to protect, you have your assets you want to protect, you need to protect it yourself.
Come on.
You need to get uninsured
Come
motorist coverage.
on.
That's what reasonable, responsible people do.
Bankers don't do that.
It costs you
Bet other
nearly
people's
nothing.
money. Bailouts.
You say that.
You know, just saying.
So we've
100,000
been talking.
would be
We've been
nice.
talking long enough. We need to pause. We'll come back. Make sure that you subscribe to our YouTube channel. We don't have active people who are paying for us to have a YouTube channel, but we expect that if anyone was looking at it, they would be looking at how many people subscribed. And so
Like
we'd
and
appreciate
subscribe.
it. Make sure you like and
Comment
make sure you
down
subscribe.
below.
It really does help us because
All your questions down below.
because we have.
Tell us what state you're from and you're watching at the
That's
bottom.
right. That's right. Because we do have interested people who want to know, like Ben, Dwayne, Bob, Irreverent D. Like, can you justify the amount of resources and time you're spending on this? You're spending on this podcast, and we'd like to be able to say, yeah, we have so many subscribers.
We
it's
just
important
want to
many.
give back to the community.
That's right. It's important
Which
to many
we would like to
people.
know there's a community out there.
That's right. That's right. We just want to make sure.
Like us.
Like us.
Love us.
Thanks for listening. Tune in next time when Bob and Irreverent D talk law.